The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, can living wills be contested? The short answer is yes, but we are going to explain what a living will is and in what situations they can be contested. So let's first talk about what a living will is. A living will is an end-of-life instruction document that is often created in connection with an estate plan. So when people get their normal will done or trust, they will often have the option to create a living will. And about half of our clients create one, half don't. There's no right answer. If you have a living will in your medical file, the doctor is instructed in the event of an irreversible coma, so 0% chance of you coming back according to the doctors, to terminate life support. Now, what's important here is normally that decision would either be in the hands of whoever you've named as your healthcare power of attorney or in your next of kin if you don't have a healthcare power of attorney. So the reason people have living wills is, one, to make sure that there's the emotional burden of making that decision to terminate life support isn't on their loved ones. They don't want their kids to have to make that decision. They want to make that decision for themselves in advance. That's why it's called an advance directive. Number two is sometimes people just don't physically want to be left in that condition for a very long time. Three, sometimes they don't want to drain the family's finances to keep them in that condition for a very long time. So a living will makes the decision of what to do if you're in an irreversible coma in advance and instructs the doctor to terminate life support. It's got to be in your medical file, and it's got to be properly executed in order to be effective. Often people have a problem with this if they are that person's loved ones. They don't want to terminate life support. So they may want to contest the validity of the living will. And this is possible. Now, when you contest a living will, you're not contesting the substance. You're not contesting the decision that person made and whether that's the right decision. All you're contesting is whether the living will was properly executed in order to be valid. So what are the requirements for a living will to be valid? Requirement number one is that the person had to have been at least the age of majority, 18 years old, and of sound mind at the time that the living will was created. They have to have signed the living will at that time in the presence of two other witnesses that were also of sound mind and also at least 18 years old. Finally, and this doesn't have to do with the execution of the document, but at the time that the death-delaying procedures are to be terminated, so the time life support is to be terminated, the person has to not be pregnant and capable of having a live birth. So if all those three things are true, then the living will be upheld and it can't be valid. It can't be invalidated through a contest. But if you think that one of those things aren't true, if there's a problem, either the person wasn't of sound mind when they executed it, or it wasn't properly witnessed, or there's a problem with the formalities of the document, and they're not pregnant at the time of the life-delaying procedures being terminated, then you can file a petition to contest the living will. We're not going to go into a lot of detail on the mechanics of how to file that petition or what the process is once you file that petition, because we have an article and video that goes into a lot of detail about it. It's called Illinois Will Contest Explained, and the process for contesting a living will is basically the same as contesting a standard will. But suffice to say that the petition has to allege why you think the will is invalid, and then ultimately a trial will be held where you have to prove, usually through witness testimony, that there were problems with the execution of the living will. And if you can do that, then the will be invalidated. And while the lawsuit is pending, you can have an injunction entered usually to delay the termination of life support until the outcome of the lawsuit. So if you have any questions, you can leave them in the comment section below the post at learn-about-law.com. We try to get back to you with an answer within a couple of days. If you found this helpful and would like to be informed of the topics of our upcoming daily article and video posts, we post every day. You can subscribe to us on YouTube, iTunes, and SoundCloud, or submit your email to be added to our email blast. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.